in accordance with our commitment and the provisions of the Constitution, we now proceed to give our decision. The petitioner was one of the candidates in the presidential election that was held on the 18th February 2016, petitioned the Supreme Court under the Constitution, the Presidential Elections Act, and the Electoral Commission Act. He challenged the result of the election and sought a declaration that Yoweri Kaguta Museveni was not validly elected and an order that the election be annulled. On the 20th February 2016, the second respondent declared the election results as follows. I've set out the results. The petitioner contends that the election was conducted without compliance with the provisions and the principles of the Presidential Elections Act 2000, the Electoral Commissions Act 1997, hereinafter referred to as the PEA and ECA, and the 1995 Constitution, and that this affected the result of the election in a substantial manner. For this, he faults the second respondent. Among the specific complaints against the first respondent are that several illegal practices and electoral offences were committed by him either personally or with his knowledge and consent or approval. The petitioner made no specific complaint against the third respondent, but several allegations were made against public servants and security personnel. The first respondent denied the petitioner's allegations of breaches of the law. The second respondent opposed the petition and contended that the election was held in compliance with the provisions of the electoral laws and asserted that if there was any non-compliance which was denied, it did not affect the results of the election in a substantial manner. The third respondent opposed the petition and also contended that the Attorney General was improperly joined as a party to the petition. All the respondents sought the dismissal of the petition with cost. At the commencement of the hearing, counsel for the petitioner applied under Article 126 of the Constitution, Section 100 of the Civil Procedure Act, and Rule 15 of the Presidential Election Petitions Rules 2001, with the miscellaneous application number 1 of 2016 to amend the petition. The application was allowed, and the amended petition was filed on the 7th March 2016. The respondents filed their answers to the amended petition on the 9th March 2016. Two applications were brought before court prior to the hearing of the petition for leave to intervene as amicus curiae in the petition. The first one, Professor Loko Nyango and others, miscellaneous application number 2 of 2016, was brought by lecturers from Makerere University Law School jointly. The second application, Foundation for Human Rights Initiative and others, miscellaneous application number 3 of 2016, was brought by civil society organizations. Court allowed miscellaneous application number 2 of 2016 and dismissed miscellaneous application number 3 of 2016. The Makerere University lecturers filed their amicus brief on the 17th of March 2016, which was copied to the parties. The hearing commenced on 14th March 2016 and ended on 19th March 2016. Article 104 of the Constitution and Section 58 of the Presidential Elections Act require that the petition must be inquired into and determined expeditiously, and court must declare its findings not later than 30 days from the date the petition was filed. Judgment was that set to be delivered on 31st March 2016. In accordance with the Presidential Elections Act, Presidential Election Petition Rules 1996, the parties filed affidavit evidence in support of each party's case. Furthermore, the chairman of the second respondent, Engineer Dr. Badru Chigundu, was cross-examined by the petitioner's counsel. Although the petitioner stated in his affidavit that he had annexed affidavit set out on a list mentioned as Annexure A, as well as copies of election observer reports, that was not the case. These affidavits were in fact never filed in court, nor were the election observer reports. The petitioner, however, filed other affidavits on or about the 10th of March 2016. At the pre-hearing conference, the parties agreed on the following facts. One, that there was a presidential election conducted by the second respondent on the 18th February 2016, that on 20th February 2016, the first respondent was declared as validly elected president with 5,617,503 votes, representing 60.75 million, I beg your pardon, of the valid votes cast. That on the 20th February 2016, the petitioner was declared to have polled 132,574 votes, representing 1.43% of the valid votes cast. The agreed issues were, one, whether there was non-compliance with the provisions of the Presidential Elections Act and the Electoral Commission Act in the conduct of the 2016 presidential election. Two, whether the said election was not conducted in accordance with the principles laid down in the Constitution, Presidential Elections Act, and the Electoral Commission Act. Three, whether if issue 1 and 2 or both are answered in the affirmative, such a non-compliance with the said laws and the principles affected the results of the elections in a substantial manner. 4, whether the alleged illegal practices or any electoral offences in the petition under the Presidential Elections Act were committed by the first respondent personally or by his agents with his knowledge and consent or approval. 5, whether the third respondent, the Attorney General, was correctly added as a respondent in this election petition. 6, whether the petitioner is entitled to any of the reliefs sought. Representation, we give the representation as it was given. This can be found in the record. Discussion and court findings. We have since completion of the hearing had the opportunity to peruse and evaluate the evidence before us. We have also studied the authorities cited to us and carefully considered the submissions by Land Council for the parties. We have made findings on each of the allegations presented to court. We are, however, not in a position to give detailed reasons for our findings and decision due to the constitutional timeline imposed on the court to render judgment within 30 days from the date of filing the petition. We shall therefore announce our decision on the issues framed, and we will give our detailed reasons and findings at a later date. Burden and standard of proof. Since Section 59(6) of the Presidential Elections Act authorizes the court to annul an election only if the allegations made by the petitioner are proved to the satisfaction of the court. An electoral cause is established much in the same way as a civil cause. The legal burden rests on the petitioner to place credible evidence before the court, which will satisfy the court that the allegations made by the petitioner are true. The burden is on the petitioner to prove not only non-compliance with the election law, but also that the non-compliance affected the result of the election in a substantial manner. Once credible evidence is brought before the court, the burden shifts to the respondent, and it becomes the respondent's responsibility to show either that there was no failure to comply with the law, or if there was any non-compliance, whether that non-compliance was so substantial as to result in the nullification of the result. Where a petitioner in a presidential election petition brings allegations of non-compliance with electoral laws against the electoral body on the one hand, and allegations of electoral offences and or illegal practices against a candidate declared as president-elect on the other, as is in the matter before us, varying standards of proof exist within the same case. For the court to be satisfied that an electoral offence was committed, the allegation must be proved beyond reasonable doubt. On the other hand, the standard of proof required to satisfy the court that the Electoral Commission failed to comply with the electoral laws is above probabilities but not beyond reasonable doubt. Evidence adduced. The petitioner relied on his amended petition as well as the following evidence to support his case. A, the petitioner's affidavit in support of his amended petition and his additional affidavit. B, B. 67 affidavits sworn in support of the petition. C. Video CDs attached to his affidavit, but which his counsel neither referred to in his submissions nor specifically introduced in evidence, and was not viewed during the hearing. D. Oral evidence adduced by the petitioner through the cross-examination of the chairman of the second respondent. E. The election results of all the 112 districts of Uganda, which included the return form for each respective district as at 20th February 2016, the results tally sheet for each district as of 20 February 2016, and the declaration of result forms for all the 28,110.
We follow that in both his initial and amended petition, the petitioner indicated that he intended to rely on the court's formulation of services.
Neither attached to the pleading filed in court, nor the copies that were served on the respondents. When counsel for the first respondent brought this matter to the court's attention, the court directed counsel for the petitioners to file the attachments and also to serve the parties. On the 12th of March 2016, counsel for the petitioner wrote counsel for the first respondent, copied to the registrar of the court, enclosing the observer reports which he had said had been inadvertently left out. However, on the 18th March 2016, before the close of the hearing of the petition, counsel for the respondent brought the court's attention the fact that they had agreed with counsel for the petitioners for the said document to be withdrawn. This position was confirmed by counsel for the petitioner. We further note that on the last day of hearing, counsel for the petitioner attempted to tender into evidence a document he referred to as a matrix, which he alleged would show polling stations where the total number of persons who voted exceeded the registered voters in the said stations. Upon objection of counsel for the respondents that the matrix was based on forgery, the court directed counsel for the petitioner to indicate the primary source of the information he was presenting. On failing to do so, counsel withdrew the matrix. The first, second, and third respondents each filed various affidavits in rebuttal of the allegations. We now go to consider the issue. Issue number one, whether there was non-compliance with the provisions of the Presidential Elections Act and the Electoral Commission Act in the conduct of the 2016 presidential election. In his amended petition, the petitioner made several allegations of non-compliance with the provisions of Presidential Elections Act and the Electoral Commission Act against the second respondent, the Electoral Commission. Some of the allegations relate to non-compliance that occurred prior to the elections, while others focus on alleged non-compliance that happened on election day, and those that happened after the close of polling at the time of declaration of the first respondent as the winner of the presidential election. Illegal nomination of the first respondent. The petition alleged that contrary to Section 9 and 10 of the Presidential Elections Act, the second respondent nominated the first respondent on 3rd November 2015, when he had been sponsored by the National Resistance Movement, NRM, on whose ticket he purportedly contested. The petitioner relied on his affidavit in support of his petition to support this allegation. The second respondent denied the allegation and contended it properly and duly nominated the first respondent after he had complied with all the requirements of the law. The first respondent also denied this allegation and relied on the affidavit of Kasule Lumumba, the Secretary General of the NRM Party, which confirmed that the first respondent was endorsed by the NRM's Delegates Conference on 2nd November 2016 as the presidential candidate for the NRM Party in accordance with its constitution. We've carefully considered the affidavit evidence adduced by the parties. We have studied the provisions of Section 9 and Section 10 of the Presidential Elections Act, which governs sponsorship and nomination of presidential candidates. We have also carefully considered Section 11 of the Presidential Elections Act, which provides for the factors on the basis of which the nomination of a person duly nominated can be invalidated. The allegations made by the petitioner do not fit any of these factors. Based on our findings above, we find that the second respondent nominated the first respondent as a presidential candidate in accordance with the provisions of the Presidential Elections Act. Illegal extension of deadline for nomination of presidential candidates. The petition alleged that contrary to section 11 of the Presidential Election Act,
the second respondent
failed to declare the first respondent's nomination papers null and void, and instead acted improperly when it extended
the deadline
to give the first respondent more time after all other candidates had submitted their respective documents. Counsel for the second respondent acknowledged that the second respondent extended the deadline for nomination. It was averred that section 50 of the Electoral Commission Act empowers the Electoral Commission to extend the time for doing any act, and that the extension was necessitated by the late passing of the electoral law reforms by Parliament. That the extension was not meant to benefit any of the presidential candidates. We have carefully considered the affidavit evidence and respected submissions of the parties. We note that indeed section 50 of the Electoral Commission Act grants powers to the Electoral Commission to extend the time for doing any act. Section 50 subsection 2 in particular provides that the provisions of section 50 apply to the whole electoral process, including all steps taken for the purposes of the election, which include nomination. We are also of the view that section 11 of the Presidential Elections Act is not applicable to the situation. Accordingly, we find that there was no failure on the part of the second respondent to comply with section 11 of the Presidential Elections Act. Failure by the second respondent to compile a national voters register. The petitioner alleged that contrary to Article 61, Clause 1E of the 1995 Constitution, Section 12F and 18 of the Electoral Commissions Act, the second respondent abdicated his duty of properly compiling and securely maintaining the National Voters Register. He further alleged that the second respondent instead illegally and irregularly retired the duly compiled 2011 Voters Register and purported to create another one using the data compiled by the Ministry of Internal Affairs for purposes of issuing national identity cards, national IDs. The second respondent contended that it properly compiled, revised, and updated the National Voters Register in accordance with its constitutional and statutory duties, that all voters were duly and legally identified as being on the voters' roll in accordance with the Presidential Elections Act. We have carefully studied the provisions of Article 61, Clause 1E of the Constitution, and Sections 12F and 18 of the Electoral Commissions Act, which govern this issue.
We have also carefully considered the affidavits and submissions of the parties and made the following findings.
1. There was a National Voters Register which was compiled, updated, displayed, and used by the Electoral Commission to conduct the 2016 presidential elections. We have noted that Section 18.1 of the Electoral Commissions Act obliges the second respondent to, quote, compile, maintain, and update on a continuing basis the National Voters Register, unquote. 2. The petitioner received a copy of the National Voters Register in his capacity as one of the presidential candidates. 3. The allegation that the second respondent used data compiled by the Ministry of Internal Affairs is not correct. The data was compiled by the National Identification and Registration Authority, on whose governing board the second respondent is a member. 3. The compilation of the National Voters Register was in compliance with Article 61, Clause 1E, and Section 18.1 of the Electoral Commissions Act, and Section 65.2 of the Registration of Persons Act 2015, which states that, quote, the Electoral Commission may use the information contained in the register to compile, maintain, revise, and update the voters' register, unquote. 4. That the second respondent's use of data compiled by the National Identification and Registration Authority to compile the National Voters Register did not in any way negate the independence of the second respondent, which is guaranteed under the Constitution. That the petitioner did not adduce any evidence of any person who had been disenfranchised by the second respondent's use of the new National Voters Register in the 2016 presidential elections. Accordingly, we find that the second respondent complied with the provisions of the Constitution, the Electoral Commissions Act, and the Registration of Persons Act. Failure by the second respondent to issue and use voters' cards during the presidential election, resulting into the disenfranchisement of voters. The petition alleged that contrary to sections 30, subsection 4, and 35 of the Presidential Elections Act, the second respondent identified voters using the national ID issued by the National Identification and Registration Authority instead of voters' cards issued by the second respondent. The second respondent admitted that voters' cards were neither issued nor used during the last presidential elections. Relying on Section 26 of the Electoral Commission Act, the second respondent submitted that that section is not couched in mandatory terms to require them to print and issue a voter's card for use at each election. Further reliance was placed on Section 66, subsection 2B of the Registration of Persons Act, 2015, which requires the mandatory use of the national IDs for identification of voters. In light of the provisions of the law cited, we find that the second respondent complied with the law when it used the national ID for identifying voters instead of the voter's card. Use of unreliable biometric voter verification machine, BVVK, and failure by the second respondent to identify voters. The petitioner alleged that contrary to Section 35(1) and 2 of the Presidential Elections Act, the second respondent failed to identify voters by their respective voters' cards, but instead applied an unreliable, slow, and suspect biometric identification machines, thereby denying legitimate registered voters their right to vote and creating room for persons not duly registered to vote. Further, that contrary to Sections 30, subsection 4 of the Presidential Elections Act, voters were identified on polling day using the national identity cards instead of the voters' cards. That as a result, eligible voters who did not register for the national identity cards were disenfranchised. The petitioner relied on the affidavit of Nakafero Monica, who was the petitioner's agent at Kasangat headquarters polling station, and who deposed that, quote, at 4 p.m., polling agents said that the biometric machine was no longer functional, unquote. The second respondent admitted that each polling station was supplied with a BVK machine whose purpose was to improve transparency and integrity of the process of identification of voters at polling stations, prevent multiple voting, impersonation, and to confirm or direct a voter to their polling stations. That each polling station was supplied with a hard copy of the voter's roll as the basic document for identification of voters registered to vote at that particular polling station. That all registered voters were duly and legally identified as being the voters on the voters' roll in accordance with the Presidential Elections Act and were allowed to vote. The second respondent further averred that the voter identification was three-faceted. One, use of the BVVK through verification of a voter's fingerprints. Two, use of national identity cards. Three, use of a hard copy of the voter's register at the polling stations. There was evidence that some of the BVVK machines were not efficient and some did not work at all. However, the principal document used to identify voters was the voter's register. It is therefore finding that the use of the BVVK did not in itself constitute non-compliance under the Presidential Elections Act and did not disenfranchise voters. Late delivery of polling materials. The petition alleged that contrary to Section 28A, B, C of the Presidential Elections Act, officials of the second respondent delivered voting materials late on election day, and that at many polling stations, voting did not commence until 2 p.m., 4 p.m., and 8:30 p.m. in some places, and ended after 1 a.m. The petitioner relied on affidavit evidence of several deponents to support these allegations. The second respondent averred that the late delivery of election materials occurred only in some polling stations in 2 districts out of 112, to wit, Kampala and Wakiso. It was further averred that in the affected polling stations, the time for voting was extended and voting was carried out and completed. It denied that there was any polling which commenced at 8:30 p.m. and or went on up to 1 a.m. anywhere in the country. The second respondent relied on the affidavits of its chairman and other officials. The respondent conceded that polling material in some parts of Kampala and Wakiso were delivered late. Evidence was adduced of late delivery of materials in some other polling stations in other parts of the country. In the court's finding that the second respondent, it is the court's finding that the second respondent did not comply with its duty under Section 28 of the Presidential Election Act. The failure to deliver polling materials to polling stations within such a close proximity to the Commission was evidence of incompetence and gross inefficiency by the electoral body. Failure by the second respondent to control polling materials. The petition alleged that contrary to Section 12B and C of the Electoral Commission Act, the second respondent failed to control the distribution of ballot papers and ballot papers and ballot boxes. There are some errors. Some typos. Resulting in the commission of numerous election offences in that unauthorized persons and or officials of the second respondent got possession of election materials and used them to stuff the ballot boxes, tick the ballot papers on behalf of voters, vote more than once, and or doctor figures in the declaration of result forms and tally sheets. The petitioner relied on the affidavit evidence of 2 deponents to support this allegation. The second respondent averred that it carried out its duty of distributing ballot boxes and papers in accordance with the law, and only authorized persons handled the polling materials, declaration of results forms, and tally sheets. This allegation encompasses several other allegations made by the petitioner, which include starting voting without opening ballot boxes, pre-ticking, and stuffing of ballot papers, which we deal with in our subsequent discussion. Starting voting without first opening ballot boxes. This assertion by the petitioner was not supported by any other evidence. In the absence of evidence of persons who witnessed incidents of voting without opening ballot boxes, the court finds that non-compliance has not been proved. Allowing voting without secret ballot. The petition alleged that in some places, such as in the Chirhura district and the Kato corridor, voting was not done following the principle of secret ballot. The petitioner relied on the affidavits of Kenneth Kasule Kakande, his appointed agent at Nyogoga Barracks, Nakaseke district, who claims that when the voting started, the ballot box was not sealed and the voters were dropping the votes in the open box rather than through the hole on top of the box. The same witness claimed that a security official stood near the basin where the voters were taking their votes and thus compromising the secrecy of their ballots. The second respondent denied that any voting was carried out in breach of the principle of secrecy of the ballot as alleged by the petitioner. This claim could not be verified by the court. It is therefore finding that the allegation is not. Pre-ticking and stuffing of ballot papers. The petitioner alleged in his petition and in his affidavit in support that there was pre-ticking and ballot stuffing at polling stations in favor of the first respondent. Several affidavits were shown in support of this allegation. There was, for example, the affidavit of Rahangari Elias and Amanyire Fred, who were presiding officers in some polling stations in Changwali, Oima district. They deponed that they were instructed by Nelson Atmanya, the electoral supervisor of Changwali sub-county, to take any unused ballot papers in favor of the first respondent and put them in the ballot boxes. Atmanya in his affidavit strongly denied this allegation. We find his affidavit in rebuttal more credible. There was the affidavit of Patrick Gustin Orwata, who claimed that he was a registered voter at the Lolo polling station. He deponed that he saw pre-ticked ballot papers in the RDC of Ayam's car on the 18th of February 2016. This statement was strongly refuted by Akulu Julian, the RDC of Ayam district, who deponed that she was not in Ayam district on that day, but was in Lila district where she had gone to vote. This allegation was also refuted by Nab Kenya Teddy, the returning officer of Ayam district, who deponed that the Loro polling station does not exist in Ayam district. We also considered the affidavit of Mark Dad from Nalkorongo, who deponed that the presiding officer of Nalkorongo polling station M2N returned to the polling station with pre-ticked ballot papers at 4 p.m. This affidavit was also strongly refuted by the respondents. We've carefully analyzed the affidavit evidence of both parties, and we find that the evidence contained in the affidavit evidence in support of the petitioner's allegation is not convincing. We therefore find that this allegation has not been proved. Voting before and after polling time. The petition alleged that contrary to Section 30, subsection 2 and 5 of the Presidential Elections Act, the second respondent allowed voting before the official polling time. The petitioner did not adduce any evidence to support this allegation. The petitioner further alleged that contrary to Section 30, subsection 2 and 5 of the Presidential Elections Act, the second respondent allowed voting beyond the official polling time by people who are neither present at the polling stations nor in the line of voters at the official hour of closing. The petitioner relied on his affidavit to support this allegation. The second respondent contended that the petitioner had not adduced any credible evidence of voting before official polling time. It was further asserted that all voting after polling time was a deliberate measure taken by the second respondent in accordance with Section 5 of the Electoral Commission Act to mitigate the effect of the late delivery of polling materials at the affected polling stations. The second respondent relied on the affidavit of his chairman and other officials. The petitioner is the one who asserts that there was polling before and after polling time, but there is no other evidence as to the circumstances under which voters voted outside the time allowed by the law, except for those places where the chairman of the second respondent explained the circumstances under which he extended voting to enable voters where voting material had been supplied so late. On that basis, and given the vague nature of the allegations, we found no cogent evidence of non-compliance. Multiple voting. The petition alleged that contrary to Section 32 of the Presidential Elections Act, the presiding officers in the course of their duties allowed some voters who had already voted to vote more than once. The petitioner's allegation was supported by 4 deponents. The second respondent contended that the petitioner had not adduced any credible evidence to support the alleged multiple voting. The second respondent asserted that he took measures, including upgrading of the voters' register to include biometrics and introduced a biometric voter verification system to enhance the transparency of the electoral process and the integrity of the result. The second respondent further vowed that the BVVS was designed to eliminate the possibility of multiple voting and that no incident of multiple voting was reported to the second respondent on polling day. The second respondent relied on affidavits of its officers. We have considered both the petitioner's affidavits and the affidavits in rebuttal, and we find that 2 of the petitioner's affidavits are based on hearsay evidence, and 2 are in respect of incidents where the deponent claims to have seen polling agents issuing 4 ballot papers to 1 voter, and another where a deponent claimed to have seen a lady being issued with 2 ballot papers. But there is no evidence whether the ballot papers were actually cast as alleged. We find no evidence of multiple voting because the allegations could not be verified given the nature of the evidence adduced before us. Allowing unauthorized persons to vote in the presidential elections. The petition alleged that contrary to Sections 30, subsection 4 and 35 of the Presidential Elections Act, the presiding officers in the course of their duties allowed people with no valid voters' cards to vote or denied those who had cards from voting. The second respondent contended that no credible evidence had been adduced by the petitioner to support this allegation as well. It averred that only voters appearing in the National Voters Register could be identified were allowed to vote. Counsel for the respondents admitted that the Electoral Commission's improvements in the National Voters Register and voter identity verification technology, biometric voter verification system, eliminated the possibility of unauthorized voting. This was supported by affidavits of the respondents' officers. The petition relied on the affidavits of 3 persons. One of the deponents was Waguma Amos, who stated that he saw some individuals who turned up at the polling station when they were not on the register. He does not state that these individuals voted. There is also the affidavit of Sezibera Moses, who deponed that he saw an underage voter at a polling station, but does not mention that he saw him voting. Then Kasule Kakande, who said that he saw around 50 youth at a polling station dressed in UPDF uniforms, who appeared to him to be below 18 years. Apart from his own perception that they were below 18 years, there was no other evidence that they were indeed below 18 years, and he has not stated whether that their names were not on the register. This evidence does not prove that anybody eligible to vote was allowed to vote. Prevention of petitioners' agents from voting. The petitioner alleged that contrary to Section 76B of the Presidential Elections Act, his agents and supporters were abducted and some arrested by some elements of the security forces to prevail upon them to vote for the first respondent or to refrain from voting. The petitioner did not adduce any evidence by way of affidavit to support his allegation about his agents being prevented from voting. Chasing away of petitioner's agents from polling stations. The petitioner alleged that contrary to the provisions of Section 33 and 48, subsection 4 and 5 of the Presidential Elections Act, his polling agents were chased away from the polling stations in many districts, and as a result, his interest at those polling stations could not be safeguarded. The petitioner further averred that contrary to Section 33 of the Presidential Elections Act, the second respondent's agents, servants, the presiding officers failed to prevent the petitioner's polling agents from being chased away from polling stations, and as a result, the petitioner's agents were unable to observe and to monitor the voting process. The petitioner relied on 10 affidavits to support this allegation. All the 3 respondents denied this allegation. The second respondent in particular contended that the petitioner had not adduced any credible evidence of the second respondent's involvement in chasing away of the petitioner's agents. The second respondent relied on the affidavit of Engineer Badrojo. Having considered all the evidence, all the affidavits in support and in rebuttal, we have found it difficult to believe that the absence of the petitioner's polling agents in the districts that were cited was caused by the chasing away of his agents. When we looked at the declaration of results forms of the polling stations where this allegedly happened, especially in areas like Wankole, Kamuli, we found that his polling agents actually signed the declaration of result forms. We also noted that this allegation would have been more credible if the polling agents in the polling stations allegedly involved had shown supporting affidavits. Denying petitioner's agents information. The petitioner complained in his petition that contrary to Section 48 of the Presidential Elections Act, his polling agents were denied information concerning the counting and tallying process. Apart from his own affidavit, other supporting affidavits were shown by his polling agents who were allegedly affected by the denial of information. The second respondent contended that the petitioner had not adduced any credible evidence to support this allegation. It averred that all voting and tallying was conducted in full view of the public at polling stations and tallying centers. The second respondent generally denied this allegation, but we did not see any affidavit filed specifically in rebuttal of the petitioner's allegation in supporting affidavits. Having carefully considered the affidavits in support of the petitioner's allegation, we find that in some cases, the petitioner's polling agents were indeed denied information to which they were entitled. Alleged non-compliance by the second respondent during the process of counting, tallying, transmission, and declaration of results. The petitioner made the following allegations of non-compliance by the second respondent, which we shall consider together under this section. 1. Counting and tallying of election results in the absence of petitioner's agents. Under this allegation, the petitioner contended that contrary to Section 49 of the Presidential Elections Act, the second respondent's agents, servants, allowed voting and carried out the counting and tallying of votes in the forced absence of the petitioner's agent, whose duty was to safeguard the petitioner's interest by observing the voting, counting, and tallying process and ascertaining the result. The petitioner relied on the affidavit evidence of 7 deponents to support his allegation. The second respondent denied this and adduced affidavit evidence to show that at all polling stations, the counting of votes was done openly and in the presence of candidates' agents who chose to be present. Our analysis of the evidence provided to us shows that at most polling stations, counting of votes was smooth and transparent. Only in a few of the polling stations were there reports of incidents. There is also evidence that the petitioner did not actually have agents at all polling stations. Declaration of result forms without the declaration of results without the declaration of results forms. Under this allegation, the petitioner contended that the declaration of the first respondent as the winning candidate was illegal, unlawful, because under Section 54 of the Presidential Elections Act, the returning officer is required to receive all the envelopes containing the declaration of result forms in the presence of the candidates or their agents before opening the same and adding up the number of votes cast for each candidate as recorded on each form. He further contended that the second respondent instead announced provisional results without the returning officer receiving all the declaration of results forms. He further contended that the announcement was a calculated scheme by the second respondent to manipulate and cook the figures that made the first respondent appear to be in the early lead. The petitioner relied on the affidavit evidence of 2 deponents. The second respondent contended that it used the Electronic Results Transmission and Dissemination System, ERTDS, to transmit results, the primary source of which were declarations of result forms from polling stations. We have noted that Section 54(1) stipulates that a returning officer should open envelopes containing the declaration of results forms when all the envelopes have been received. Section 54, subsection 2 of the presidential elections, on the other hand, allows a returning officer to open envelopes and add up votes even though all the envelopes have not been received. This should only be done where the candidates or their agents and a police officer not below the rank of Inspector of Police is present. The petitioner appears not to have addressed himself to Section 54(2). His claim, therefore, insofar as it does not address Section 54(2), is misconceived. Evidence on record shows that returning officers opened envelopes where all envelopes had not yet been received. It was stated in evidence that the second respondent had to declare results within 48 hours from the end of polling. The results were transmitted as they came in. This was permitted under Section 54(2). We find that there was no non-compliance with the Presidential Elections Act. Unlawful electronic transmission of results from districts to the National Tally Center using ERTDS. The petitioner alleged that the second respondent, without receiving the requisite documents under Section 56(2) of the Presidential Elections Act, announced the results of the election and declared the first respondent as the winning candidate, contrary to Section 56 of the Presidential Elections Act. The petitioner relied on his affidavits in support his allegation that the use of ERTDS was unlawful. The second respondent averred that it was in possession of the declaration of results forms from polling stations before announcing the results and declaring the winner. The second respondent also submitted that he used the ERTDS to transmit results, the primary source of which were the declaration of result forms from polling stations. The system could also produce tally sheets based on information from the declaration of result forms. The second respondent further averred that in any event, receipt of the said document by the second respondent is not a prerequisite for announcing the results of the presidential elections. We have carefully considered the evidence and submission of parties. The allegations of the petitioner with regard to the electronic transmission of results brings into focus the operation of Section 56 of the Presidential Elections Act. Section 56(1) provides for the returning officer, after adding the votes as per Section 54(1), to declare to all those present, including agents of candidates, the results obtained by each candidate. Thereafter, he has to complete a return indicating the number of votes obtained by each candidate. Section 56(2) is the crux of the matter, which states as follows. Upon completing the return under Section 1, the returning officer shall transmit to the Commission the following documents. A, the return form. C, the tally sheet. B is repeated. T, the tally sheet. And B, the declaration of result form from which the official addition of the votes was made. The petitioner contends that the above documents were not submitted to the second respondent. His agents did not see them, and therefore there were no results to use to declare the first respondent as the winner of the presidential election. For the second respondent, it was submitted that the above documents were scanned at the district and the results were electronically transmitted to the second respondent. The hard copies followed later. It was the electronically transmitted results that were used to declare the winning candidate. This brings to focus the use of technology in the conduct and organization of elections. The law requires that the returning officer transmits the documents, but does not specify the mode of transmission. We received evidence that in the past results could even be transmitted by phone or fax. We have addressed ourselves to the legal meaning of the word transmit. According to Black's Law Dictionary, 9th edition, it has two meanings. It can mean to send or transfer a thing from one person to another, but it can also mean to communicate. We have also considered the provisions of the Electronic Transactions Act, 2011, and have concluded that in the absence of specific provisions as to the mode of transmission, the second respondent, while exercising its authority to organize and conduct elections, could use electronic transmission of the documents under Section 56(2). This is not non-compliance with that provision. However, care would have to be taken to ensure that the information received by the second respondent could be verified as being consistent with that on the original documents that were scanned. This is the basis for the petitioner's demand for discovery and inspection of the declaration of result forms, the return form and the tally sheet. In his petition, the petitioner stated his case thus in paragraph 36, subparagraph 6, and paragraph 37. In paragraph 36, paragraph 6, he stated thus, and we quote, "From the above process, there was room for switching the DR forms, switching the results, when purportedly tallying and doing all malpractices of reading to alter the final result." Then in paragraph 37 he states, "In this regard, the declaration forms used by the second respondent to declare results are essential and critical to determine whether the results announced correspond to the declaration forms in possession of the second respondent vis-a-vis those in possession of the petitioner and other candidates. The petitioner shall seek for their disclosure and discovery from the second respondent." The petitioner's team of lawyers and data specialists did inspect the said documents at the offices of the second respondents. They were subsequently given certified copies by the second respondent, and by agreement of both parties, certified copies of the same were exhibited in court. The petitioner failed to produce those declaration of results forms he said were in his possession, so that he could make comparisons with the documents in court and establish any discrepancies. No material discrepancies were discovered or brought to the attention of the court. illegal and unlawful declaration of the first respondent as winner of the presidential election without the district returns and district tally sheets. Under this allegation, the petitioner contended that without declaration of result forms from each of the 28,010 polling stations, together with the tally sheets from the 112 districts and return forms, there were no results that the second respondent could use to declare a winner under Section 57 of the Presidential Election Act. Based on this allegation, the petitioner claimed that the second respondent had no basis to declare the first respondent winner and contended that Section 56 of the Presidential Election had not been complied with. The petitioner relied on the affidavit. This evidence was rebutted by the affidavit evidence of the second respondent's chairman and other officials. Mr. Chubundu was also cross-examined on it, and his evidence was not shaken. We have carefully considered the evidence and submission of the parties. We find that based on the documents which were exhibited in court by mutual consent of the petitioner and the second respondent, and which we have perused, we are satisfied that the results that were declared by the second respondent on 20th February 2016 were based on tally sheets and returns submitted by returning officers from the 112 districts as at 20th February 2016. We have found no non-compliance with Section 56 of the Presidential Elections Act because at the time of declaring the first respondent the winner, the second respondent had already received results from 26,223 out of 28,100 polling stations. There is a mistake, which is 28,010, not 100. Okay. The second respondent, however, confirmed that by the time it announced the winner of the presidential elections, it had not yet received results from 1,787 polling stations, representing 1,057,720 registered voters. The second respondent contended that it announced the results because the first respondent had already emerged as a clear winner with more than 50% in his favor, and because it had to comply with the constitutional and statutory requirement to declare a winner within 48 hours from the close of polling. We note that the petitioner took particular issue with the second respondent's announcement of a winner before all results were turned in by the respective returning officers. We recognize the very short timeline of 48 hours imposed on the second respondent to ascertain and declare the results and the winner where one has attained more than 50% of the votes cast. We have noted, however, that the second respondent did not, in its answers, provide any credible explanations why the results of 1,787 polling stations had not been received. With the exception of a few stations where the entire polling exercise was cancelled, we find it inexcusable for the remaining results not to have been sent by the returning officers. A review of the district summary report issued by the second respondent as of 20th February 2016 showed that while distant districts had either fully submitted their results, some districts such as Jinja had only transmitted results for 11 polling stations, representing only 3,607 valid votes out of a total of 399 polling stations of the district. These delays explain the 0 votes reflected for several polling stations in some district tally sheets that the petitioner brought the court's attention from the districts of Jinja, Rukunjiri, Chenjo, Jokabari, Kampala, and Wakiso. Following the completion of the hearing, the court reviewed the district summary report, final results as of 22nd February, and confirmed that the missing results were eventually included in the final tally. We also did not observe major discrepancies in the results that were transmitted by the respective district returning officers through the district tally sheet and district return forms and the results for each district, which the second responded on 20th February 2015. Lack of transparency in the declaration of results. The petition alleged that contrary to Article 1, Clause 4 of the Constitution, the election and the whole process of counting and consolidating the election results through tallying and transmission of results from each polling station to each polling station, the district tally center, returning officer, and finally to the purported national tally center lacked fairness and transparency. He further contended that the process was instead shrouded in mystery and concealment in announcing the results and declaring the winner. The petitioner further alleged that the second respondent did not have a national tally center established by law and instead received results from illegal tally center run and operated by security agencies at Naguru. Besides his affidavit in support of the petition, the petitioner did not adduce any other evidence to support the allegation that the second respondent received results from an illegal tally center based at Naguru. He, however, relied on the affidavit evidence of 13 deponents to support his allegation that the declaration of results lacked transparency. The second respondent denied the petitioner's allegation that there was no national tally center and that it received results from illegal tally centers. The second respondent averred that it had a well-established national tally center at the Mandela National Stadium at Nambole, from which results from district tally centers were relayed. Further, the second respondent averred that there were no illegal tally centers from which the second respondent received results. The second respondent relied on the affidavit evidence of its chairman and other officials. We note that Section 57(1) of the Presidential Elections Act requires the Commission to ascertain, publish, and declare the results of the presidential election within 48 hours. However, the Presidential Elections Act does not prescribe for the Electoral Commission how a tally center is set up to ascertain results nationwide, how it should look and where it should be located, what it should look like. We note that the petitioner made an allegation that the second respondent received results from an illegal tally center which was being operated by security agencies. The petitioner did not adduce any evidence to support this allegation. With regard to the allegation of non-compliance arising from the second respondent's setting up of a national tally center at Nambole, we have found no provision in the law which the second respondent breached when it set up the national tally center to enable it to collect and ascertain the results it had received from the districts before it could declare the winner in 48 hours, as it was required to do so by the Constitution and the Presidential Elections Act. Based on our review of the law and evidence before us, we find that the petition has not proved that second respondent failed to comply with the cited provisions of the Presidential Elections Act. We, however, wish to note that the second respondent should have done more to ensure that all candidates and their agents were properly briefed about the mode of transmission of results at both the district level and at the national level, national tally center. Failure to accord equal treatment or coverage by state media agencies. The petition alleged that contrary to Section 12(1)(e) of the Presidential Elections Act, the second respondent failed to accord equal treatment to the petitioner when it failed to prevail upon the authorities and government agencies such as Uganda Broadcasting Corporation and the New Vision to render equal coverage to the petitioner to enable him to present his programs, but they offered preferential treatment to the first respondent. The petitioner relied on one affidavit to support this allegation. The second respondent contended that it executed its duty of educating all media houses on their responsibilities in the election period and issued guidelines to media houses for that purpose. Further, it did not receive any complaint from the petitioner to that effect. Section 12(1)(e) of the Electoral Commission Act requires the Electoral Commission to take measures that will ensure that the entire electoral process is conducted under conditions of freedom and fairness. We note that under Article 67 of the Constitution and Section 24(1) of the Electoral Commission Act, they require that all presidential candidates shall be given equal time and space on state-owned communication media. The second respondent, in its rebuttal, adduced evidence to show that it briefed media houses and also attached media guidelines, which it issued to all media houses with respect to their obligations to grant equal access to all presidential candidates. We have also noted the affidavit evidence of Robert Kabushenga and the attachments thereto, including a report of the African Center for Media Excellence in rebuttal to the petitioner's allegation, which actually showed that the new vision gave fair and impartial coverage to all the presidential candidates. While the law grants equal access to all presidential candidates on equal coverage on state-owned media, we also note that it is incumbent on the presidential candidate to prove that he or she sought coverage and took all the necessary steps to contact the state-owned media, and that the media houses either refused or denied him that coverage. In this particular case, the petitioner did not adduce any evidence before court to show that he had taken any of the steps outlined above, and that he had lodged any complaint with either the media houses in question or the Electoral Commission about an equal coverage. We have also noted, however, that whereas Uganda Broadcasting Corporation and New Vision may have been wholly owned by government at the time the law in question was enacted, the situation has since changed. Today, the New Vision Printing and Publishing Company Limited is a public listed company. We have carefully studied the provisions of Article 67(3) of the Constitution and Section 24(1) of the Electoral Commissions Act, which govern this issue. We have also carefully considered the respective submissions of the petition and the respondents with respect to this allegation. We find that it is true that the Uganda Broadcasting Corporation failed to provide equal coverage for all the presidential candidates as required by the Constitution and the law. Although the candidates may not have asked for the airtime from the UBC, it was incumbent upon UBC to show that it did offer time and space to all the candidates. The second respondent had no control over the management of UBC, and once it issued guidelines to all media houses, including UBC, it cannot be held responsible for another public corporation's failure to obey the law. The non-compliance was by UBC and not the second respondent. We further note that the issue of an equal media coverage of state media has been a recurrent issue in previous election petitions. Unfortunately, no penalty is provided for under Section 24 of the Presidential Elections Act for non-compliance. This is an area that requires legal reform so that the public media houses can be compelled to comply with the law. Failure to conduct free and fair elections resulting from use of police and military presence at polling stations. The petition alleged that contrary to Section 12(1)(e) and F of the Electoral Commissions Act, the second respondent failed to ensure that the entire presidential electoral process was conducted under conditions of freedom and fairness, and as a result, the petitioners and his agents' campaigns were interfered with by some elements of the military, including the special forces and the so-called crime preventers under General Kale Kihura. The petitioner relied on the affidavit evidence of 7 deponents to support this allegation. The second respondent denied this allegation and contended that the petitioner had not adduced any evidence to support this allegation. It averred that the election was conducted under conditions of freedom and fairness, in that all polling stations were manned by presiding officers assisted by polling assistants and an armed election constables supervised by the presiding officers. The second respondent relied on 3 affidavits of its officials, including the returning officer of communities. There was affidavit evidence from General Katumba Wamara and some other officers that indeed there was deployment of the Uganda People's Defense Forces in some areas to support the police force to maintain security. This evidence is further to the effect that there was intelligence information that there were some elements that wanted to disturb the peace during elections, but it was denied that the soldiers or the police engaged in any violent acts or intimidation. Section 43 of the Presidential Elections Act prohibits the carrying of weapons by any person to within 1 kilometer of the polling station, end quote, unless called upon to do so by lawful authority or where he or she is ordinarily entitled by virtue of his or her office to carry arms. Therefore, in the absence of evidence of actual intimidation or violence, the mere presence of police or army is lawful where called upon by lawful authority. Intimidation. During the consultations, evidence was adduced by the petitioner, supported by evidence of Hope Mwesige and Benon Muhanguzi, that as he was proceeding to Mbale to hold a consultative meeting about his candidature for President of Uganda, he was intercepted at Jinja and brought back to Kampala, where he was kept for a day at Shira Road Police Station. The Inspector General of Police, in support of his action, states that after consulting the NRM party, the Electoral Commission and the Attorney General on the candidature of the petitioner and relying on intelligence reports from Mbale, he stopped the petitioner from proceeding to Mbale on security ground. Court finds that there was interference with the petitioner's aspirant consultation meetings in Ijeru, Jinja, Soroti, and Kapchorwa. Court further finds that the interception of the petitioner en route to Mbale and his detention at Shira Road Police Station was unjustified and high-handed and was contrary to Section 3 of the Presidential Elections Act. During campaigns, the petitioner, supported by affidavit evidence of Unduga Rogers, Mugabe Lawrence, Semakura Saduk, Med Mapehu, Ozima Ramadani, claimed that his supporters, including all witnesses named hearing, were arrested from go-forward offices in Nakasero, detained in Chireka, and later taken to Tungamo, where they were charged in court for offenses of assault, which they never committed. The arrest of these witnesses was related to an incident in Tungamo, where the supporters of the petitioner and those of the first respondents clashed at the rally. The case was subject to police investigations and is pending court trial. The petitioner, supported by evidence of Hope Mwesige, Benon Muhanguzi, and Kokunda, alleged interference with his rallies by supporters of the first respondent who also tore his posters. In response to the allegations of intimidation and disruption of the petitioner's rallies, the first respondent relies on a number of affidavits, including the ones of Ronald Chibule, Muhozi, Mugabe, and Odokonyero. After analysis of the affidavits for and against the petition, we find that there were clashes of supporters out of the various candidates during which candidates' posters were defaced. However, we have found no evidence to associate the first respondent with the alleged intimidation and disruption of rallies. During voting, a group of witnesses, namely Tumusime Gerard, Juma Bai, David Mubiru, Sewanyana Joseph, Tito Sky, all describing themselves as members of a jobless group called Chifes, testify as to how they were hired by the NRM mobilizers to beat up opposition supporters in parts of Kampala, including Lugala, Nakulabye, Kawala, and Nasana, which they accomplished. The credibility of these witnesses is doubtful, and we cannot rely on them to make a finding that opposition supporters were assaulted by the supporters of the first respondent before and during polling. There was no evidence of any of the victims of the assault that could have supported the story of the Chifes group. Issue number: whether the said election was not conducted in accordance with the principles laid down in the Presidential Elections Act and the Electoral Commission Act. The principles which have been laid down are: A, freedom and fairness, that the election must be free and fair. B, transparency, that the voting, tallying, and transmission of results should be done in conditions which are transparent. C, secrecy of the ballot. The voter should cast his vote or her vote in complete secrecy and not in the open for anybody else to see. D, equal suffrage. Each person aged 18 years and above should be entitled to register and vote. The petitioner contended that the election was not conducted in compliance with the above stated principles The allegations made on this issue have already been covered in our consideration of issue 1, and we shall not need to repeat it. Based on our earlier findings under issue number 1, we find that there was non-compliance with the principles of free and fair elections in some areas where there was interference with the petitioner's aspirant consultative meetings, where there was late delivery of polling materials, failure by Uganda Broadcasting Corporation to give the petitioner equal treatment with the first respondent, and interference with petitioner's electioneering activities by some elements of police, some RDCs, and some GSOs. Issue number 3. Whether, if either issue 1 and 2 or both are answered in the affirmative, such a non-compliance with the said laws and the principles affected the results of the elections in a substantial manner. We note that both the Constitution, Article 104, Clause 1, and the Presidential Elections Act, Section 59, Subsection 1, provide that an aggrieved candidate may petition the Supreme Court for a declaration that a candidate declared by the Electoral Commission as an elected president was not validly elected. If the allegation is proved, the consequence would be annulment of the election. Article 104, Clause 9 of the Constitution, provides that Parliament shall make such laws as may be necessary for the purposes of this article, including laws for grounds of annulment and rules of procedure. The Presidential Elections Act is rooted in the above specific constitutional mandate given to Parliament, and in its section 59(6)(a), the Act provides the grounds which the Supreme Court can rely on to annul an election. Section 59(6)(a) of the Presidential Election Act provides, and challenging the presidential election, the election of a candidate as president shall only be annulled on any of the following grounds if proved to the satisfaction of the court. A, non-compliance with the provisions of this Act if the court is satisfied that the election was not conducted in accordance with the principles laid down in those provisions, and that the non-compliance affected the result of the election in a substantial manner. The import of Section 59(6)(a) is that compliance failures do not automatically void an election. Where a party alleges non-conformity with the electoral law, the petitioner must not only prove that there has been non-compliance with the law, but also that such a failure to comply did affect the results of the election in a significant manner. Counsel for the petitioner made a passionate plea to this court to depart from its decisions in Presidential Election Petition number 1 of 2001 and number 1 of 2006, in which the court held inter alia that in assessing the degree of
on the result of an election, numbers are important. In both cases, the court held that the court cannot annul an election on the basis that some irregularities have occurred without considering the mathematical impact of the irregularities. In the opinion of counsel for the court placed undue reliance on the quantitative testing in interpreting the phrase affected the result of the election in a substantial manner. It said an extremely restrictive and nearly impossible to meet testing. In applying Section 59(6)(a) to the matter terms, we were aligned to the spirit ingrained in Chapter 1 of the Constitution, which deals with the sovereignty of the people and provides that the people shall be governed through their will and prosperity. Clause 4 specifically states that the people shall express their will and consent on who shall govern them, and how they should be governed through regular free election of the representatives of the land. We opine that the import of Section 59(6)(a) is that it enables the court to reflect on whether the proved irregularities affected the election to the extent that the LC results do not reflect the choice of the majority of voters vis-a-vis the draft provision of the Constitution, and in fact negated the voters' vote. It is important that the court asks the question, given the national character of the system, where all voters in the country form a single constituency, can it be said that the important effects so seriously affected the result that the result of no provision is said to represent the community of the majority of voters? The petition alleged that the results announced by the second respondent, declaring the first respondent as winner, were manifestly different from the votes cast before this. The petition sought for the disclosure and discovery of the electoral platform used by the second respondent to declare results in order to determine whether the results announced correspond with what was recorded in the clear terms of the possession of the petition. And the owner of the result, the discovery was further available at this time. The consent of the parties, the documents were assisted in court this image. Court had the opportunity to examine the evidence of the possession of the result. There was no evidence of discrepancy between what was recorded in the form and what was declared by the result. The results used by the second respondent to declare the first respondent as winner were based on the characters. The election of last one introduced important evidence for the procedure. The petitioner did not produce any other form which he said was not. Court therefore no way of proving whether or not what was in the possession of the petitioner required in the official record of the second respondent. The petitioner therefore failed to describe the value of proving the allegation. But serious discrepancies existed between what was declared by the second respondent and what was declared by the first. Court has been guided by the principle that in democracy, the election of a leader is the preserve of the voting system, and that the court should not grant part of the results due to the expression of the population political intent. Inherent in the sector is the clause that the fundamental consideration in an elected country should be whether the will of the majority has been pushed by the non-constituents. This is the very clause on which the electoral constitution is. In defining what constitutes a valid election, we must be guided both by both the Act for People Sovereignty as well as the Act for providing for challenging the validity of the election. Both constitutional provisions must be respected. We must however emphasize that although the mathematical impact of non-compliance is critical in determining whether or not to annul an election, the court's evaluation of evidence and the result indicated is not exclusively based on the completed process. But must also consider the nature of the election. Analysis of the presidential election results in case-by-case analysis of the evidence and this comparison. If there is evidence of such a substantial matter that the Constitution entitled that the process of this have been provoking the divorce of men and by the big scale of the serious implications of what elections could be, the court will allow the court's exercise judicial independence and discretion to allow the analysis of the presidential election results in a case-by-case analysis of the evidence. On the one hand, the court must avoid according to the presidential results, and on the other, we must avoid announcing an election result that reflects the full year of the election. The majority of those rights are inherent to Article 1 of the Constitution. In the method before us, we find that there was non-compliance as proven in this one and two, but we are not satisfied that the non-compliance affected the result in this Constitution. Issue number 4. Where the alleged illegal practices or any electoral offences in the petition under the presidential contract were committed by the first respondent personally or by his agent with his knowledge and consent or approval. Section 59(6)(c) of the presidential contract provides that the election of the candidate as president shall be annulled if it is put to the respondent and to refrain from voting the petitioner and other presidential candidates. In reply to the allegation, the first respondent deponed that while he was campaigning in Terebo Western, the people asked him for a pause in support of their children's education. He informed them that there was already an ongoing government program under which oil was redistributed to the people of Northern Uganda. He promised to inquire into what had happened to the implementation of the program. Thereafter, the first respondent wrote a letter dated 20th November 2018 to the Prime Minister, in which he directed that in the financial year 2016-17 budget, the purchase of 18 million was excluded. The Prime Minister, Wakana Gunda, avowed in his affidavit that he received the above-mentioned letter from the first respondent in his capacity as president. He then traveled to Terebo and informed the people that the whole program was ongoing. He presided over and witnessed the distribution of posts. In further support of the first respondent's reply, it was informed by the Chief Administrative Officer of our district that in January 2016, he received calls from the Office of the Prime Minister for distribution as had been done on 2 previous occasions long before the campaign. We note that the first respondent's letter to the Prime Minister was to the effect that it would be budgeted for in the next financial year, which would be after the campaign period of elections. The evidence on record also indicates that the supply of goods people in Northern Uganda commenced in the 2013-14 financial year. It is therefore final that the first respondent did not engage in Contract Section 64(1) and 4 of the Presidential Elections Act, between May 2015 and the 16th and 18th February 2016, the first respondent, through his agents and with the knowledge and consent or approval, gave a bribe of 250,000 shillings to voters in every village throughout Uganda on 2 occasions with the intent that they should vote the first respondent to refrain from voting the petitioner. He repeated what he stated in his allegation as above. In addition, there were 3 other affidavits. In response, the first respondent saw an affidavit and stated that, to his knowledge, the money was paid out by the National Resistance Party to its branches to support its activities. This is affidavit evidence was supported by a detailed affidavit of the Secretary General of the NRM, Justice Bart Katureebe, who stated that the money was to facilitate party branches to compile village registers, purchase of writing materials, food and refreshments. There were over 20 other affidavits in support of the respondent's reply. Section 64(3) provides that the offense of bribery does not apply in respect of provision of money to cover expenses of a candidate's organization meetings or campaign planning. It is therefore finding that the first respondent did not engage in bribery as alleged. But that contrary to Section 26B of the Act, the first respondent organized a group under the Uganda Police Force, a political partisan militia, the so-called crime preventers, under the superintendency of the Inspector General of Police, General Kalekiura, a paramilitary force cum militia, to use force and violence against persons suspected of not supporting candidate Yoweri Kaguta Museveni, hereby causing a breach of peace, disharmony and disturbance of public tranquility, and induce others to vote against their conscience in order to gain unfair advantage for candidate Yoweri Kaguta Museveni. The evidence before court by the petitioners was a repeat on oath what is stated above. The first respondent stated in rebuttal that the crime preventers referred to are a reserve force, that it was a concept of community policing where people work with police. People volunteer to ensure that there is no crime in their village. The police give some rudimentary training, and it is a concept which works in other countries.
they are conscripted, whereas ours is simply voluntary. The joining is voluntary, and in so doing, one becomes a reserve. The affidavit of the third respondent in support to his answer corroborates the first respondent's evidence by stating that the Uganda police force is mandated by the Constitution to cooperate with the civilian authority in execution of their mandate, and that it is in furtherance of this cooperation that crime preventers under community policing are trained, and further that it is through cooperation with crime preventers that law and order is maintained and life and property protected in communities. We carefully perused and considered the petitioners and respondents' evidence in this allegation. The evidence adduced by the petitioner did not prove that the first respondent had organized the crime preventers for the purpose as alleged. That contrary to section 24(5)(a), Roman 1, Roman 2, B, C, and D, and 7 of the Act, of the Presidential Elections Act, the first respondent on several occasions threatened to arrest the petitioner and candidate Shiza Besigye, and used derogatory and reckless language when he stated that the petitioner and his supporters had touched the anus of the leopard and would see what would happen to them, and this had the effect of scaring voters to vote for the first respondent for their own safety. The petitioner adduced no evidence to substantiate this. The first respondent admitted making the statement, but denied that the allegation referred to the petitioner or any other candidate. We have considered the affidavit in response by the first respondent, and we find that the words referred to did not have the meaning attached to them by the petitioner. Contrary to section 24(5)(a), Roman 1, 2, B, C, D, and 7 of the Act, Presidential Election Act, the first respondent on various occasions threatened that if the voters elected the petitioner or anybody else, Uganda would go back to war, and this had the effect of influencing voters to vote for the first respondent so as to maintain the status quo. This was denied by the first respondent. We have considered the above evidence and case law referred to us by counsel, and find that the allegation was lacking in substance, in that the various occasions referred to were not named and actual words used were not pleaded. Contrary to section 27 of the Presidential Elections Act, the first respondent made use of government resources which are not ordinarily attached to and utilized by the President without proper authorization by law, thereby having unfair advantage over your petition. The petitioner repeated on oath what was stated in the petition. In particular, he stated that the first respondent involved civil servants such as Allen Kajina, Executive Director, Uganda National Road Authority, and Jennifer Musisi, Executive Director of Kampala Capital City Authority, in his political campaign in Kanungu and Kampala respectively. There are affidavits in support of the first respondent's answer to this allegation of Ms. Allen Kajina and Jennifer Musisi. They gave the functions of the Executive Director of UNRA and KCCA under the law. Being public officers, they were called upon by the first respondent to explain the ongoing programs and were not involved in his campaigns. The third respondent's affidavit in support of the first respondent's answer to the amended petition corroborates the first respondent's evidence. In effect, that Allen Kajina and Jennifer Musisi, Executive Directors of UNRA and KCCA respectively, are not government resources, but public servants who are called upon by the first respondent to explain ongoing programs and never campaigned for the first respondent. We have carefully perused and considered the evidence on record, and we are satisfied that the two public officers were acting in their own capacity as public officers. They had not gone to campaign, but to explain government programs. In the result, we find that this allegation that the first respondent misused government resources was not proved. Issue number 5. Whether the third respondent was correctly added as a respondent in this petition, in this election petition. The petitioner contended that the petition variously points out the role of security organs, specifically the Inspector General Police, Uganda Police, the UPDF, in interfering with his consultative meetings and campaigns. That these complaints justified the need to join the Attorney General as a party to the petition. The Attorney General contended that it is wrongly joined in the petition since the Presidential Elections Act rules describe a respondent to the petition as the person whose election is complained about, and the Electoral Commission, where the complaint includes the conduct of the Electoral Commission. It should be struck out from the petition with costs for that reason. We agree with the Land Deputy Attorney General that the rules, as they now stand, do not envisage the Attorney General as a respondent to a presidential election petition. However, our view is that the allegations against government officials could only be answered by the Attorney General in its capacity under Article 119 of the Constitution. We are of the view that in the future, the law should be amended to make the Attorney General a respondent where there are allegations against government and its officials to participate as a party. Issue number 6, whether the petitioner is entitled to any of the reliefs sought. The petitioner sought the following reliefs. A, an order for vote recount in 45 districts mentioned here. Counsel for the petitioner did not lay any ground for the prayer for recount in the 45 districts. We have perused and analyzed the evidence on record and are of the view that it was not necessary to order a recount as prayed. B, a declaration that the first respondent was not validly elected as president. C, an order that the election of the first respondent be annulled. C, D, costs of the petition be awarded to the petitioner. Prayers B, C, and D are answered in the decision of the court. Now, the decision of the court. Having made due inquiry into the petition, on the basis of our findings set out in the judgment, we hereby declare that the first respondent was validly elected as president in accordance with Article 104 of the Constitution and Section 59 of the Presidential Elections Act. Accordingly, this petition is dismissed. We make no orders to post. Before we take leave of this matter, we would like to point out may I remind you, court is still sitting. Before we take leave of this matter, we'd like to point out a number of areas of concern. Some of the areas that seem to come up at every presidential election. We don't want to have to throw out anybody.
Can we have some order, please? Can we have some order, please?
I will repeat. Before we take leave of this matter, we would like to point out a number of areas of concern. Some of the areas that seem to come up at every presidential election include: 1, an incumbent's use of his position to the disadvantage of other candidates. 2, use of state resources. 3, unequal use of state-owned media. 4, late enactment of relevant legislation, etc. We must also note that in the past 2 presidential petitions, this court made some important observations and recommendations with regard to the need for legal reform in the area of elections generally and presidential elections in particular. Many of these calls have remained unanswered by the executive and the legislature. We have looked at some of the election observer reports. Although the reports point to several instances where the observers found irregularities and malpractices, the main thrust of these reports must be still be directed at the need for structural and legal reforms that would create a more conducive atmosphere that would produce genuinely free and fair elections. The Citizen Election Observer Network, Uganda, CION, makes this very important observation, and we quote, Uganda's legal framework limits the foundation for conducting credible elections. These limitations prompted civil society to produce the Citizens Compact on Free and Fair Elections, which includes recommendations for legal reform, overhauling the Electoral Commission to ensure independence and impartiality, reforming the demarcation of electoral boundaries, ensuring recruitment of polling officials is done in a transparently, competitive, and based on merit, and the establishment of an independent judiciary to adjudicate on electoral disputes impartially. These recommendations were not taken up for the 2016 elections. At the hearing of this petition, we allowed as Amici Curiae a group of prominent constitutional scholars from Makere University. They have given us a brief on issues pertaining to the holding of free and fair elections in Uganda. Suffice to say at this point that it is high time that the executive and the legislature started seriously to think about the crucial need to address legal reforms in our electoral laws. We shall consider these proposals in deeper detail when we give our full opinion. Dated at Kampala, this 31st day of March 2016, and signed by all the 9 justices.